This is Dale. I want to take a moment to explain to you what we'll be doing in this session. This session is about listing agreements, including the documents that are associated with listing agreements. We will go through each one of the documents, explaining how it works. We will go through the checklist that's involved with the app files to help you understand how that's done. This will take approximately 3 to 4 hours. Good luck, and here we go. All right, again, first time you move from workspace into compliance and then is once you have the first 4 documents. Now, what you do is you go in and you change the status is what you're doing. That's all you do, and that immediately changes it. And now we'll get notified. The second time I'm going to pay attention to your file is when I get number 9. Now, number 9 is extremely important. Sending me a copy of the deposit check, sending me a copy of the form you filled out to submit the check to either signature title if they're holding it or whoever else is holding it is wonderful. But so far you've given me useless documents. Well, the check is not useless. I need the escrow verification that shows the escrow agent signing that they received it. So you can put in the one that you sent with the check. That's wonderful. I need that sucker signed. So you need to make sure, because by law, we have no more than 10 days to notify the escrow agent that we need written verification. And then we have no more than 10 days to notify the other side. When you get down to number 9 and you have the written verification, that's when I'll move it to pending. Because see, pending in apps files is different than pending in the MLS. So when I say that I will, after 9, I will put it in the pending file. It's the pending file for apps files, not for MLS. Because most of this stuff will now happen just prior to or just after closing. Because the last thing that should show up in this list is number 13. Because obviously you can't close without the certificate of approval, and if you close, you got a HUD statement, you got commission checks. Now, if it's your listing, I will not authorize your check until the closed sale is in there. If you are on the other side and it's not one of our companies, then I will not penalize you because the other company took 3 weeks to take it from pending to closed. What I will do is I will show it as a closed sale and then put a attached there that says, when available, please upload the MLS closed. Just as a reminder so you don't forget that you still have one more thing to do for the file to be complete. But I'm not going to hold back your check for something you can't control. You also want to make sure, if you're the selling agent, that the listing agent identifies you as the selling agent on the sold. Because there's a place at the bottom, because if you pull it up after it's gone to sold, there's a place at the bottom where it shows who actually sold it. And a lot of agents are slick, they'll put their name there. Or they won't put anything at all. I want credit for that sale, because when I go on a listing, I can say to them, I had 5 listings in here last year, I sold all 5 of them. But I also sold 10 other properties, see? Well, if they don't make that switch so it shows you as the selling agent, guess what? To me, I don't tell the seller I sold 10 other properties if I can't prove I sold the 10 other properties. So keep that in mind, because now it becomes a big difference. 5 and 5 is nice. 5 and 5 and 10 tells that seller what? I have buyers. And do you think if the seller thought you had the potential for a lot of buyers, it would encourage them to list with you? Duh, because if I can't produce buyers as the listing agent, I got a little problem. but to show that I can sell my own. See, whether I sold it or not is irrelevant. I don't point that out. They want to ask, I'll tell them. But I sure be glad to point out that I sold other properties for other agents. Now, certificate of approval. If you're on the listing side, the odds are you're not going to get a copy of the certificate of approval if you don't ask for it. Because obviously the certificate of approval, you're not even involved in the application process to get it. That's the selling agent's responsibility. Obviously you try to do anything you can to speed it along if you can, but you're not the one really responsible for that. It's the selling agent is. And the certificate of approval, a lot of times is sent directly to the closing agent. Why? Because it's happening a few days before closing sometimes. Sometimes the morning of closing. I've had situations where the people flew down in the morning, went to their interview, got the certificate of approval, and went to closing. And whoever was doing the interview and stuff actually emailed it or faxed it to the closing agent. So again, a lot of times you may not see that certificate of approval until you get to closing. You may not see it at all, other than laying on the table as the listing agent. But you need to get a copy of it. Why? I need that in the file to justify there was no issues with them closing. Because you know that the contract and the condo addendum says they can't move in until what? They have approval if approval is required. Well, I need documentation. So you have to realize anything that I need to prove, I have to have in black and white. Now, that second form you had in there, this is the old form. This is when there's a bottom part to it, just in case you ever run into it. If you get a checklist that does all that stuff at the bottom, you have the wrong checklist. This was when you actually had to send the documents to me and I put them in a file. So everybody understands now you never have to send me a document. If it applies to a particular transaction, even if you still have it in the workspace. Let's say you have it in the workspace and you're about to go out on the listing appointment and you want me to look at it before. Just send me a task. Just say, can you please review the listing contract and forms. I'm about to go on an appointment. I want you to review them. So I'll jump in there as quick as I can, review them, and get back to you. It might be a phone call. And, you can still pick up the phone and call me, but most communications you can do through there. And you can do, basically on the homepage of the listing, or the file, you can send me a message or you can send me a task. I have a tendency to pay more attention to the task than I do to just the messages. Tasks have urgency to it. Any questions on the checklist? See, you never have to wonder if you have all the documents you're supposed to have if you're using the checklist. Because I have obvious things missing from the file that if they were using the checklist, wouldn't have it. For example, lately, for whatever reason, I'm having a rash of when you're doing the listing, I'm getting the listing agreement and any addendums, but I'm not getting the county records, I'm not getting the MLS active. Now, obviously, they've already pulled both of those. Because if it's already in MLS, then obviously that form is there, they just didn't put it in there. County record should have been pulled before you even went on the listing appointment. And remember this, any time you need a document in your file that's not in your computer, where you can upload it, all you have to do is email it. So if you're in MLS and you just converted it to active, you just finished filling it out, it's now active, you can go in, you can copy the email address in your apps, you can go over to the MLS, and you can put in that address as a client. And then you can email it right into the app file. You don't have to print it out, scan it in your computer, and then upload. So anytime you want to put files in the app or documents in the app, no matter who they're coming from, send them that link, that email address. Because if you send it for signature, the system automatically, when they finish signing, it automatically goes back to the apps file, which is so slick. Because if you send it to your seller to sign it, they sign it and initial it. As soon as they've signed and initialed everything, it takes it right back to the app file and dumps it in there and sends them a copy of what they just signed. Which means when you're filling out a form, you don't ever have to touch paper. You can take a listing and do those first 4 things without touching a piece of paper. No, you might have to in the county records. I'm not sure if you can email them there. Another thing with the apps files, if you got duplicates, delete. Don't leave documents in there you don't need. For example, a lot of agents say, well, I'm going to put in the escrow verification form, even though I haven't got a signature yet, which is fine. Then when you get the signature, you're not going to have 2 of those. You need to eliminate the one that you sent. Why? Because the second page now has everybody's signature on it. It has your signature when it went away from you. It has the closing title agent, or excuse me, the escrow agent's signature on it. Okay. All right, let's begin our trek here. First thing I want to take a look at is the listing agreement. All right. When it comes to the listing agreement, first thing is the seller's name. Second thing is the broker's name. Who's the broker? No? Whatever company you're working for, thank you, is the broker. Ben's not the broker. You don't work for Ben. You work for Signature, or you work for Kings Point, or you work for Glen Eagles, or you work for Century Village. You don't really work for Ben. You're not, your independent contractor agreement wasn't with Ben. Ben only signed on behalf of the company that you're employed to. So now you can't go right into Ben to get your check each week, every 2 weeks.
Gale, what is the full name of Signature Residential?
Signature Residential Real Estate LLC, or Signature International Real Estate LLC. And that's the name you need to use in any marketing or advertising you do. Why? Because that's the licensed name of the brokerage firm. So just using Signature International is not proper. You're not going to get your head taken off and handed to you on a silver platter, but you need to put the full name. Now, how do I find the seller's name? See, because when I get in front of the seller, I'm going to ask them to verify the names. Or I may ask them on the phone. Who has to go on the listing agreement?
Both owners?
Yeah, however many owners there are. When I look at the deed, whoever's on there has to be on the contract. If I had a traditional life estate, the remainderment would have to be on that contract. With the enhanced, they still retain the right to be able to sell it, so we don't need the remainder. What if you have this situation? You have a homestead owned by the wife. Who needs to go on the listing agreement? Wife and husband, or
Just the wife.
just the wife?
Just the wife.
Both.
It would be both.
Because when it's homestead, even if a spouse is not an owner, they have rights in that homestead that they don't have in any other properties. Therefore, they both need to be on that listing agreement. And one spouse cannot sign for another spouse without the power of attorney. Because you'll get, don't worry, I can sign for my wife. transaction. This is legal. You know, maybe it's true. The wife doesn't have a problem with it. The husband doesn't have a problem with the wife signing. They do it all the time. I don't care if they do it all the time. If one spouse is going to sign for the other, I need official documentation that they have the power of attorney to do such. So will the title company. Or if they will not accept the contract. Because if somebody's signing there that's not that person and signing for that person, the title company is not going to recognize that contract without documentation that that person had the right. And if I'm aware that one spouse signed for another and there's no indication, I need to make sure that's disclosed, which obviously would not make them happy. Now, you have a homework assignment after this class is over. And you'll have a homework assignment after the next one and after the next one. The homework assignment is this. You're going to find a corner in your house. You're going to get either a bottle of wine or milk or water or whatever it is turns you on. And you're going to sit there until you've read all these documents from the first word to the last word. Because I expect you to be able to answer any question about that document that's on that front. And until you can do that, you need to keep reading. Why? Because you need to know what that 10-page document says. And I'm not going to sit here and read line by line. Certain places I'm going to emphasize because there is a lot of fill-ins and there are a lot of ifs, ands, and buts that you need to be aware of. But some of this stuff is standard stuff. It doesn't change from transaction to transaction. And if you want to know what it says, all you have to do is read. So again, I'm not going to read word for word because that would take hours. The second paragraph, number one, acknowledges that this is an exclusive right of sale listing. What does that mean? The fact that it's an exclusive right of sale listing, what's it mean?
That you're the only one that
Well, number one, I'm the only one with the listing. More importantly,
promotes.
we get paid no matter who sells it. If you're wondering if we use any other type of listing, the answer is no. In commercial, the listings are totally different anyhow. So this is more of a residential comment. You wouldn't be using a listing like this if you were listing a commercial property anyhow. Totally different documentation. Now, in this second paragraph, there's several points being made. Number one, let's say you had this situation. Your listing's going to expire September the 30th of 2012. However, you're under contract to close October the 12th, 2012. Which means there's going to be about a 12-day period between when the listing expires and closing. Do I need to extend the listing in order to protect my commission? Yes or no?
No.
Why?
Says so right
Oh,
here.
because it says so right here. Right here is where.
First
Now, understand every question I ask you today, don't look up, look down if you're looking for the answer. Because it point blank says in there what? Once I'm under contract, the listing extends automatically until closing. I don't know if you use the word automatic, but it extends until closing.
Yeah, it does, yeah.
Yeah, because the word automatic is not really a good word to use when you're talking about a listing contract. So in other words, I don't have to extend the listing to protect my commission. It's already protected. When I sign this listing agreement on behalf of the broker, am I promising that we're going to sell the property? No. What am I promising? That I will make a diligent effort, which is farther down the page. There's also a comment there about discrimination. There's no tolerance for discrimination, people. It's too risky to your license. You need to get your fanny out of there. If they start talking about who they do and don't want you to bring through that door. I don't care if you can talk them out of it. They are now dangerous. The fact that they said to you, okay, show whoever you have to, when they were so emphatic that they didn't want to show it to X. I don't trust them. My luck, the first buyers I bring through will be X. And they will say what in front of them? I told you I wasn't selling it to any of them. Now what do I do with the rest of my life? Because my real estate career is now over if those people want to turn me in. Because you know if you get caught discriminating, what's the chances of you keeping your license? What's the chances of ever getting another one? Okay, so like I said, you're going to need to find another career. But I think we all know that. I mean, that's been drummed into your brain. But better I walk away than risk the fact. I'm not going to change a bigot's mind by telling him the law won't allow us to do it. Then the next thing here, the seller is acknowledging that they actually own the property and have the right to convey it. Find just another place to verify it. Another good place to verify it is the deed or a survey. So don't rely solely on the county property appraiser.
Dale, do we get a copy of the deed from the property appraiser?
Yeah, if you go, when you're in the property appraiser and it lists the owners and you see the last 3 or 4 sales, there is a button there because they give you a book and page number in the clerk of the court's records for the deed. So when you click on that, it'll take you right to the deed.
Can you print it?
Yep, absolutely.
Okay,
I
and
don't know if
actually-
you can email it. I can't remember right off the top of my head, but
It's amazing. So anybody can go in.
Yeah.
Print
Public
it.
record.
Public record.
it's public record.
And that's on the website. What website is that?
County property appraiser.
Fraser?
Mm-hmm. How many of you have that sheet of all the important websites that I have?
I think I do somewhere. I
Okay.
just gotta.
Well, somewhere is your desktop of your computer. That's where somewhere is.
Okay.
If you don't have, if you don't know what I'm talking about, you don't have it. Send me an email and say, send me the websites. All you have to put is send me the websites. It's a Word document.
Yeah.
But what it is, it's the county property appraiser, the clerk of the court, the tax collector, and the school board's websites for Broward, Dade, Palm Beach,
Okay.
Martin, and St. Louis. So pretty much covers anything that you'll be dealing with. And because it's actually hyperlinked on the page, all you have to do is go to control, hit the control key and click on it. It'll take you right there. Personal property. I recommend when it comes to personal property, you have 2 things. Documents and pictures. I don't care if it's just the basic appliances or if it's fully furnished. You want to make sure you identify those things. Because sellers never switch things up. Or a buyer will swear on a stack of Bibles that there was a chair there. Well, the inventory list doesn't help me verify that, but the pictures do. What they did is they confused this unit with another one they looked at that did have the what? The chair. Because the odds are they're right. There was a chair there. It's just not this unit. But again, personal property is an area that can be a nightmare. You don't assume. If it isn't in black and white, it doesn't exist. And it starts with the listing. Obviously, it's not as critical at this point as it's going to be down the road when you have a sales contract. Line 20 talks about occupancy. I'd like for you to take 1 second, read line 20. Right here. Now, based upon what you just read, I have a question. You're sitting at the kitchen table with Mr. and Mrs. Sullivan, and they're not there. And they've been living in this unit since they bought it 10 years ago. Would you check on line 20 that it is or is not currently occupied? I've got an is, I've got an is not. What do you say? Is or is not? Is or is not? Is or is not? Is? Is not?
Can you repeat it again?
Yes. Looking at line 20, would you mark is or is not if you were sitting in front of Mr. and Mrs. Seller at their kitchen table?
Not. That says currently occupied by a tenant.
Oh, thank you. If you read it, it says by a tenant. It doesn't say by the owners. But you would have to be able to read. And I've come to the conclusion after 35 years, real estate agents can't read. And the longer you're in the business, the worse your reading aptitude gets. Because you think you know everything. I find it, you know how many times I've looked at contracts and they have, Mark, I know it's wrong. I know there's no tenant there. Because there will be other information there, like a copy of the lease. Because if there is a tenant there, we need a copy of the lease. Then the next area you get into price. Now price, you probably will have to insert when you get there. But see, if you have your computer and they're wireless, or even you can go on their computer and go right into the app files and have them sign everything. So if you're meeting with them, you don't have to have paper. You can have them sign right online. No problem. You don't even need a computer, as long as they got one. Which is great.
They can sign on an iPad.
Yep, sign on an iPad, absolutely. Absolutely. They can actually freehand sign on an iPad. iPad. Then of course financing terms, obviously at minimum, conventional. For those of you that are working on properties outside of the 55 plus communities, I would click conventional FHA and VA. Because you know what, as a seller, if I have any sense, I don't care where you get your money from. Get your money from wherever you get your money from. Just show up at closing with it. I don't care if it's cash or conventional or FHA or VA. I'm open to anything as long as you show up at closing with what you're supposed to. I don't care. And see, the seller needs to understand that's basically the attitude they should have. Which means, as a listing agent, I want to see pre-approval letter or verification of funds as a part of your offer. Because as a listing agent, I'm going to ask for it if you don't have it. Why? I'm not going to my seller and talk up how wonderful your buyer is when I don't even have documentation that they can afford to buy this place. The fact that you put it on a piece of paper means absolutely nothing unless you got proof. That's why we don't start making offers if we don't have a pre-approval or proof of funds. It just doesn't make any sense. It's a waste of time, especially in today's world. And don't expect me to get all excited because you say you're paying cash. This is Florida. Give me proof. When it comes to money, I need to see it black and white. The next thing is seller financing. Now, seller financing, well, do you think I should hold financing? If they ask me for my opinion as to whether they should hold financing or not, I probably would advise them if they have an attorney to speak to their attorney because of the legalities and the risk of holding financing. I think since I've been here a year ago, we've had 2,000 transactions. I've had one, maybe two situations that were seller financing. And guess what the buyers did? They overpaid for the property, which helped lower the risk of the seller in holding that financing. And they probably put down about 20%. Overpaid and put down 20%, so it worked out for everybody.
Yeah, back to cash. What's an acceptable verification? A certified statement of account?
Yeah.
Or Is it certified, notarized, or?
Well, it needs to come, let's say that you're getting it from a financial institution.
Right.
It needs to be signed by somebody of authority in the financial institution. Or if you got a stockbroker, then we'll verify that you have accounts with them that, have sufficient funds. See, I don't need to know how much money the buyer has. As the selling agent or the listing agent, I just need to know they have it. So all I'm really asking from whatever source that they're giving me the proof from is that they have sufficient funds in an account there
Cover the sale.
to cover the sale. And you know what? They're going to put down 20%. I might want to have that letter along with a pre-approval. Well, you know what? To get a pre-approval, guess who's going to have that letter? The underwriter of the lender. Well, you're not going to get, not going to get a pre-approval. Because remember, pre-approval means they verified income, assets, and credit history. If they haven't done that, that's a worthless piece of paper as far as I'm concerned. Yes.
Well, I'm getting a step ahead. Assumption of existing mortgage.
The chances of having an assumption won't happen unless it's FHA. Unless the existing mortgage is FHA or VA, you're not going to see any
I was going
assumptions.
to say, it sounds very complicated.
No, it's actually very simple and it costs the buyer less money than new financing.
So it only work if it's an FHA?
Yeah, because FHA and VAs are the only ones that are fully assumable. You still have to meet the qualification requirements. They're not, without that, they're not. Simply don't check the boxes. You don't have to mark them up. However, you're going to have a seller every once in a while who wants the paragraphs X'd out. Because they refuse to hold financing, and they don't even have an existing mortgage on the property. So they want it marked out. Don't get into it just with them. Just mark it out. But if you mark anything out, you have to have their initials. Just like in a sales contract. If you mark something out and change it, or just mark it out, period, you have to have initials. Why? Because if the contract has been altered, I have to have evidence that the parties to that contract, or in this case, the seller, agreed to that. Whether it's to their favor or not to their favor is irrelevant. But again, I don't have to do that. I just leave the boxes blank. That's why these contracts were designed that way. So if the box isn't checked, it's not applicable. But again, I'm not going to get into a tizzy with them over that. Broker obligations. See right here, broker agrees to make diligent and continued efforts to sell the property until a sales contract is pending on the property. There, see, because we said we're not guaranteeing a sale in the second paragraph. But in this paragraph, we are acknowledging that we're going to make a diligent effort. Now, question. At this point, would a smart seller ask me what diligent effort I'm going to make? Absolutely not, because I've already told them that in the listing presentation. I don't wait until I have a contract in front of them to explain what I'm going to do. Why? Because that statement's about yay wide. It's not very specific, is it? And it's more like whatever I feel like doing is what it's saying. Well, I've already explained to you what I'm going to do. That's what the listing presentation, or part of it, is about. See, when I get to this point, they should have very few questions about what I'm going to do or not do. I should have explained all that to them. Now, this next section here, lines 40 and 41, I can live with line 40 being checked. If they want to check line 41, get up and leave. Because if they check line 41, they are saying they don't want this put on the internet, which means that we just eliminated about 90 to 95% of the marketing and about 90% of the buyers. Because that's where about 90% of them start. Even if they have an agent. Also, see line 44 where it's asking for initials? You only put those initials there if you've checked the second box, which means you're never going to have initials there. Because those initials are acknowledging that line 41 was checked. Why? Because it's so extreme. Especially in today's world. They don't want it on the internet. You know, unless I've got a buyer in the office waiting to sign an offer, I probably am not too interested in this listing anymore. I think it would be very rare that somebody would even question that, but you never know. You never know. The next one talks about that you have permission to put for sale signs or sold signs. Again, you may get the seller's permission, but the associations may not allow it. So this is getting the seller's permission. Obtaining information relating to present mortgages on the property. For example, if this is a short sale situation, I need the seller to contact the lender and get a form that the seller can sign authorizing me to speak to the lender. Because if it's a short sale, I need to be able to communicate with the lender. If it's just a situation where they've got an existing mortgage and it's going to be paid off when they sell it, and there's plenty of equity in the property, so there's no problem with that. And then the next one talks about placing an MLS. I mean, there's nothing there that's really that involved. Questions on any of that? Anybody? Okay, let's go to page 2. First part of page 2 talks about the fact that we will provide objective market analysis to buyers. Question. No, I'll get to no. I'll skip that. The next part of this is lockbox. If we put a lockbox on, who's responsible if the key is lost or if somebody steals all their furniture? The seller. Why are we putting the lockbox on there?
To be able to show.
Ease of entry.
Ease of access, right, to be able to show it. So that, I don't have to be there every time it's shown with the key, or they don't have to come to the office and pick up the key. In today's world, nobody's going to want to do that. So it is important that we make the property as accessible as possible. That's why when I talk about merchandising with them in the presentation, we talk about preparing that house so we can show it. In other words, like, put your valuables away. Of course, we also know, too, when we're talking about working with buyers and we're talking about showing property, we don't let the buyers roam free throughout the house and have one going this way and one going that way. We try to, kind of like cattle, we try to herd them through the house. We let them discover the house. We stay out of the way, but we stay within eye and earshot of what they're doing. Because when I'm showing property, I need to see the physical reactions that buyer is having to the property and how the husband and wife are relating to it. If you see them kind of snuggling up and getting close to each other, that means they feel what here? They feel comfortable. This feels like home. Whereas they're looking at each other like, what kind of hellhole is this? You get a message real quick that you kind of are not on the same plane as they're on. Because remember, we talk about qualifying the buyer up front for their needs, but that qualification process continues all the way through until you have a contract. Because what they told you up front is 180 degrees from what they're going to wind up buying. Of course, that's another class on another day. Now, the last part of this, lines 56 and 57, there's a box that talks about withholding verbal offers, and then withholding all offers once I have an executed contract. Now, let's go back and let's talk legal for a second. By law, what offers do I have to present? Now, define what you mean by all.
Well, verbal, written.
Oh, so verbal, written, how about the possibility of an offer? For example, I've got a written offer with a deposit. I've got a verbal offer, and I just got a call from a broker in West Palm that says they're putting an offer together, they'll have it to me by 11 p.m. Now, which one of those three do I make the seller aware of? Why? It's required by law, but why?
Well, because he's selling.
Because it's not your house. And you don't have the right to decide whether that offer is good, bad, or indifferent. You do have the right and the obligation to put your 2 cents in after you show it to them, or make them aware of it, as to what your feelings are about it. You're there to guide them. You're not there to make a decision. It's not your property. We forget that sometimes. You know, it's almost like we're talking to the kids. No, we're not kids. Every people buying or selling this. Now, here's my thought in how I would deal with this. If I leave those boxes unchecked, I've got to keep presenting offers until we have a closing. If I check both of those boxes, I can present those offers up until closing, but I don't have to. So in my mind, I would like those 2 boxes to be checked. Because then if I get a verbal offer, nothing stops me from calling the seller and saying, hey, I have a verbal offer. If the second box is checked and we now have an executed contract, but I'm not so sure that this is going to fly, I may continue to present offers to my sellers and take those offers as a backup to the initial contract. But see, if I have the boxes checked, then I control whether that offer is presented or not. If they're not checked, the law controls whether or not they're presented. Because if I don't check those 2 boxes, I'm presenting all offers that come along, whatever they are, until we get to closing. I don't know about you, I probably would tick off the seller doing that.
Is this withhold verbal offers the same as what it's saying with the written? Well,
No.
you know what I mean?
No.
Like it's saying accepts a sales contract.
Right.
for
Sales
property.
contract has to be in writing, right?
Right. So
Why?
Well,
Right. And what says it has to be in writing to be enforceable? Statute of frauds. Thank you.
Well, I don't understand though. So this you have to withhold all verbal offers? All.
Yeah, if you check them, what it means is you don't have to present verbal offers. So if somebody, agent calls you up and said, I got a buyer that wants to make a verbal offer, you can say to them, well, my seller will not consider verbal offers. You have to put it in writing. Or I can pick up the phone and call the seller and say, hey, I know we talked about the fact that you didn't want verbal offers, but I got one. Are you interested in hearing about it?
Oh, okay.
If I don't check the box, I just have to call up the seller and say, hey, I got a verbal offer.
Okay.
But if that box is checked and a verbal offer comes along and I don't like what I'm hearing,
You don't
I can basically just ignore them. If the box is checked.
Okay.
Same thing if I check the second box. See, also too, once I have an executed contract, if it's a good solid contract, I don't want another offer because it may be $3 better. We can almost guarantee it's going to be $3 better. So we don't want to get involved with that. So once we have an executed contract,
Yeah, I mean I think that one makes sense. For the verbal offers, I mean, I would think you'd want to.
not necessarily. I would rather put a written offer in front of my seller with either a deposit with the offer or a deposit once we have a signed contract.
Okay.
But the point is, if the box is checked, it doesn't mean I can't present a verbal offer. It means I don't have to.
Okay.
So understand that when you're checking that box, it's not eliminating verbal offers. It's eliminating the requirement that they all have to be presented to the seller.
Right. Okay. Yeah.
So it puts me in control. That's why I would check the boxes.
Okay.
you're more comfortable leaving them blank, knock yourself out. I don't, it's nothing, it's not a legal issue. It's a practical issue. Everybody okay with that? Line G talks about the fact that we are transaction brokers. Please go to the next page, if you will. There's a whole paragraph there on the fact that we're a transaction broker. We are not single agents. The reason that I don't like single agency let's start with the reason I like single agency, and then we'll talk about why I don't. I like single agency when I'm taking a listing because it's very few agents today are single agents. So it makes it one more thing you are supposedly offering them. The only problem is this. If I sell it or anybody in my company sells it, we got a problem. We're going to have to go to that seller and get them to transition to transaction broker. And I've seen over the years in doing that, that's caused more problems than the good the single agency did in getting the listing. I would focus more on what I'm going to do for them and how I'm going to get that home sold and the things I'm going to help them do than on the single agency. Because for this reason, they don't really care how you represent them. They're concerned about two things: how much and when. Besides the fact, I have enough issues with people following the rules for transaction broker. I don't want to bring in the single agency and then the transitioning stuff, because I've had to deal with that throughout the years. It's been difficult because I've had several agents ask me about it because of that. But that's my feeling with that. So is that to say that we would never allow somebody to be a single agent? No. But to me, in the long run, it proposes more problems in today's world. If everybody else was single agents, that'd be a different story. Because then you wouldn't be competitive. And then you could really use that. I think in some of the niche markets, you've got agents that never work with buyers. They only work with sellers. Some of these small boutique offices. Or they only take listings, they can't stand buyers. So basically, somebody else is going to sell the property. In those kind of situations, where rarely do I ever have the possibility of both sides. Or I'm a real small office, so we don't have a problem. Different story. Now here, if you were Signature International, it would only fix the signature. See, that's where it gets confusing. The Kings Point agents, if they showed it, would not have to transition because it's another company. But the internationals would have to transition, so it gets complicated, and that's and it's complicated enough. So that's the reason. So if you thought about that, you're not wrong in your thought process, but unfortunately, it doesn't make sense. Because I've lived in both worlds. I've lived in the single agency world. Because most of the companies went that way when this stuff all changed in the late 90s. Of course, then I watched the big companies and their attorneys after they really got a handle on what this was all about. Because it was interesting when this change first came about. Because see, up until the mid-90s, you didn't have all this disclosure stuff. None of it. You can in 475 they literally put in what the notice looks like. You have to give them single agency, transaction broker, or transition. It's right there in 475. It wasn't there before. When I first started in this business, number one, the contract was 2 pages long. Actually, the contract was 1 page, and the second page was the standards. That's the sales contract. That's how big it was. And then there was a separate document that gave a few things, and then one line said, everybody represents the seller because the seller pays the commission. And it was that way until the mid-90s. And then this drastic change. We went away from dual agency to transaction broker. Now, as a transaction broker, just one little point here that I think is important. As a transaction broker, do I have any confidentiality with the buyer or seller I'm working with, or if I'm working with both of them? Do I have any confidentiality?
Limited.
Okay. Then what is the confidentiality I have? Because I've got the buyer here, the seller here, and I've got both of them. What confidentiality do I have in that situation?
You can't disclose for what you know about one to the other regarding how much they'll take,
All right, price,
price, and terms,
terms, and
motivation.
motivation. I cannot discuss that with either one. Now, see, there's where somebody who might like single agency would say, wait a minute, if it's single agency, I've got confidentiality. What transaction broker, I don't. You'll tell the other side anything. Well, no, that's not true. See, because remember this, our transaction broker here is everybody else's no brokerage relationship. You go up in the Northeast, they still have dual agency. A transaction broker is not what our transaction broker is. If you say transaction broker from somebody from the Northeast who knows anything about it, they're not going to want to work with you. Good morning. You remember what a transaction, the no brokerage relationship? I have to deal fairly and honestly. I have to disclose material facts, and I have to disclose material facts. And the third thing is no, properly handling the escrow funds. That's my only obligations.
Okay, so when you're dealing with that New York Sharpie, and he brings it up, it's our transaction brokerage deal.
Well, see, if they bring it up, I'm going to pull out the transaction broker notice that is in the app files because it lists all the responsibilities right on the form.
But no brokerage relationship is.
It's their transaction broker.
Okay.
Because because in New Jersey, I don't know if they still do, there's like an 8-page booklet that you have to give a prospective buyer or seller that explains all this agency stuff. And I remember that when this first happened, I was working with Caldwell Bank, or actually Fair Homes and Gardens, at the National Convention. We got to discussing, agency, because that was the talk. I mean, you went to any place, anywhere, and this agency stuff, because it was happening throughout the country, was the topic of the day. Usually escrow is the topic of the day, but this agency stuff became the topic of the day. And I remember at one of these seminars, I was sitting with, they happened to be mainly Northeast trainers. And I started scribbling out what it said on the transaction broker notice, because I was doing it off the top of my head, so I was writing it up. And I got to the end, and they looked at me and said, that's dual agency. Yeah, and they're right. Because if you looked at the definition of dual agency, it says there's 3 things a dual agent has to keep confidential: price, terms, and motivation. So what they actually did is, that transaction broker is a watered-down dual agent. Because you remember in class it was the code, the 4 things that weren't in a transaction broker that actually created the single agency. No agreement for commission if they rent it. Why? Because I let them do what here? Mark it out. Which means I got to make sure what? I get an agreement between them and I in black and white that says what? That here's what my commission is going to be if you rent them. But that's the one danger of wiping that out. That does happen. That's not that uncommon. Because all of a sudden the seller realizes what? They've gotten 2 or 3 offers that are way below what they need to get out of it. And you kind of started to explain that to them initially when you took the listing. Because you realized that their needs here weren't going to be met by the market in the time frame they needed it met. That they may be better off, if they're willing to deal with it, to rent it. At least for a while.
So if the seller goes an option with his tenant, you still get your commission.
Well, yeah, I get commission on the option money, and then if they wind up buying it, I get commission
Minus the option.
minus the option. Why? Because I get paid that part. Again, rare that you're going to ever see that. Once in a blue moon, and that can probably be in a lease option or a lease purchase situation, but it's not very common. All I'm saying is, if you mark those 2 things out, B and or C, just remember that, and you're more likely to have the rental situation than you are the option situation. Just for my experience. Now, let's take a moment and read lines 96 to 102. This is a very important section.
As soon as we take a look at this, we'll take a break.
Number 2. That's one of the ones that the attorneys have a stroke over. I'll tell you the other one, just so you know. Line 90, where it says, however, closing is not a prerequisite for the broker's fee being earned. Because we ring a ready, will, and able buyer, whether you accept the contract or not, we're entitled to our commission. That's what this says there. Now, the attorney from New York that gave me such a hard time, I finally said, what do you want? She marked out that one sentence. If she had marked out number 2, she would accomplish what she was trying to accomplish. Because by marking out the fact that closing was not a prerequisite, didn't eliminate the fact that if I brought you a ready, will, and able buyer, you still owe me a commission, because that's number 2. Or if the buyer and seller enter into a contract and then decide to cancel it, I'm still entitled to my commission. Does that mean I'm ever going to collect it? No. But see, the first thing is, have I earned it? Because if I haven't earned it, there's no point trying to collect it. And then the third one is our protection period. Minimum of 180 days goes in that box right there. And if you're listening this a year, I would make that 365. What is that saying? It's saying this. Let's say a buyer inquires about the property during the listing period. But shows up 2 months after the listing expires and buys the property. That paragraph is saying what? We're entitled to our commission.
Now, you showed them the property, but like you said, 2 months later they come back.
No. I didn't show them the property. I was the listing agent. I'm talking as the
Oh, I
listing agent.
was a listing agent, okay, but our contract, expires. They come back and now it's listed with another company. And
I didn't say anything about it being listed with another company. However, your answer is line 102.
So we do get a commission.
Your line answer is line 102. Everybody read line 102 before you comment.
Oh, I see.
So if they relist, you know.
So if they relist the day after my listing expires, that paragraph just got wiped out.
If they don't list, then somebody comes.
If they don't list, it's really designed because they waited for the listing to expire so they could sell it to their friend who wanted to buy it without having to pay a commission. It's really designed for a seller who's being dishonest about, there's only a month left on the listing. Come back after that and I'll do you a better deal. That's what it's designed for. Now, an example of where you got to be careful with this. You're working with a buyer, you show them a listing. They like it, but we'd like to see others. You show them properties for the next week to 2 weeks, and they call you up one morning and say, listen, we were talking last night. Remember that home that we looked at over in Glen Eagles? We'd really like to go see that again. Everything you've shown us, we were talking last night, that home really, we should have bought it when we first saw it. So you call up the agent, and the agent says, sorry, but the listing expired. Then being a professional, I said, well, do you plan on relisting it? No, the seller's not going to relist with me. Which means now that opens the door for me to do what? Contact the seller. Okay. Now I still got this buyer. The buyer's asking me to go back after the seller. So I call up the seller. I talk to them a couple minutes. They remember me. They were impressed with how I handled myself. And I said, I have brought a buyer over, and if you remember them, they want to come back and look at your home again. Now, if they buy, would you be willing to pay me the 6% commission? They said, sure, no problem. So you go over and have them sign a commission agreement. bring the buyer back, buyer loves it, signs a contract, seller accepts it, go to closing, the other company shows up for their 3%. Why? Because I didn't comply with that sentence that said listed. Now I'm going to share that commission with the other office. So had it listed previously.
They should have relisted it at that time.
No, they should have done a written listing.
Who, we should have done a
Yes,
listing?
with the seller. You don't do a commission agreement in that situation. Because of the fact you don't comply with 102, therefore they're still entitled to their money. So it's going to cost me 3%.
So if they.
And you know what? It's going to cost you 3%. It ain't coming out of the company's money. The company didn't make that mistake. You did. That's another reason why when you have a situation like that, you probably want to pick up the phone or send me an email and say, Dale, how should I handle this? Because you make decisions on your own and they're bad ones. We had one agent that got the privilege of eating $1,500 because they made a mistake. Never. It's interesting. The paperwork got a lot better after that. Just phenomenal. But that's important because that is not necessarily an uncommon situation. But the seller says, I don't want to list. I'm glad to pay you the commission. I don't want to list. I tell you what we're going to do. I have to have a listing agreement. But I'm going to set up the listing agreement where it's strictly for this buyer. And only for this buyer. I'll put it in the additional terms on the next page. So it only obligates them if that person buys. Now I've got my listing to eliminate that having to give the money to the other company, and I've appeased them, because right now I don't need the listing for anything but that buyer. If that doesn't fly, then I might sit down with the seller and see if we can't work out something. Right now, I'm just looking to do what? Make sure I can get paid, and see if we can do this deal. But because of this, and this is a FAR Association of Realtors contract, which means it's probably the typical contract any company out there is going to use. They make some modifications to it sometimes. It's kind of the standard norm. And then this one, buyer defaults and gives up their deposit. That's what this one's talking about. Put 50% in there.
I'm sorry, what, tell me again? 103?
103, 104. How does that go over? Sometimes smooth as silk, other times avalanche. You'll have their whack on that. As long as it doesn't go under 25%, talk to me.
So, if we bring you 25%,
I won't give a cent. Anything below that, you need to talk. Or if you don't want it to drop to 25%, tell me you have to clear it through their compliance officer before you can accept them. Then we can talk. Because see, anytime that you have to potentially slice something to get the listing, my first question to you is, what kind of listing is this? Is the price good? Does it show well? Do you think you can move it quickly? Because if you think you can move it quickly, there's going to be a lot more, okay, I'm willing to go along with that. Other than, no, this is going to be a tough sale. It's a little high, it doesn't show as well as it should, then don't start looking for concessions. Because what you're telling me is going to take more time, money, and effort to get this sold, which means every day it doesn't sell costs us money. Somebody else had
So
their hand up?
this one is saying that we're splitting all
Yeah.
deposits?
Right.
With the seller?
If the buyer defaults. Let's say the buyer put up $5,000,
Right.
defaults, and coughs up the $5,000, gives it up. Well, that money is the broker, it's the sellers. But this says we're entitled to 50% of it.
Defaults as in doesn't go through with the sales contract,
Right.
you mean?
Yes.
Yes, the funds.
But you already put the 5,000.
If we got an executed, if we don't have an executed contract, this discussion is irrelevant. Because the buyer can't default if we don't have an executed contract.
Right, okay.
So I've had the listing, got the listing, buyer shows up, we have an executed contract, buyer says, I'm not buying it. Here's my $5,000, you can keep it, I don't want it. Seller says, okay, I'll go along with that.
It's pretty sweet.
It happens.
Well, they.
The buyer would rather give up the $5,000 than purchase the property. Because circumstances in their life dictated it. They had to go back to their home in Bolivia because they got family issues and they can't afford to stay and buy now. They've got to go back. Now, some sellers will be nice and split it with them. Other sellers will hold a hard line and take the whole money. And because there's other things in their life more important than that $5,000 right now, they unfortunately have to make a decision. Do I stay and fight for it, or do I get to where I need to be?
Well, even if it wasn't like a life changing.
It doesn't matter. If they refuse to close,
They
it doesn't-
have to give it. It doesn't matter what the reason is. They have to give the money. The buyer.
Well, actually,
has
it's the
to
seller's
give up the money.
decision at that point.
Oh, really?
Number one, will I let you out of the contract? I can't sue you for specific performance. If I'm willing to let you out of the contract, am I willing to let you get back any of the money? Is the second question.
Also, it's up to them.
And yeah, you're in default, buyer.
Right.
And if you screw up, you're not dictating the terms. I mean, think about that.
Yeah.
That's just logical sense. I screwed up. I'm not dictating terms anymore. It's kind of like husband and wife. Husband screws up on a regular basis, which puts the wife in control. And we never seem to learn how to get around that. And I'm not talking about anything devastating. So I'm just talking about, not, picking up my son. But fortunately, most of the stuff I do is not much worse than that, so I guess I'm good. Now, the next one is cooperation and compensation with other brokers. Here's the deal. Real simple. We give them 3% regardless of what we charge. So if we got 8%, we give them 3. If we take 5%, we give them 3. So you're not going to take a listing that's less than how much? 6%. I take 6% to be able to give them 3 and leave us with anything. If I had a seller that changed this to 3% and put 3% and said put 3% here. That's the contract the agent said, which basically means the contract agreed, or the agent agreed to work for what? Nothing.
I usually put 7 in there and see if it goes through.
Yeah. Hey, let's put it at 8 and I'll go to 7. Guess what?
And I was trying.
Nothing moves. Because says, you know what? Best I'll do is 6.5. Okay. Why? Because I got 0.5% more than I had to. It's called negotiating. This is a business deal. We forget that this is a business deal. And as a business person, I'm being hired to provide a service. I want to get paid for that. I want to be paid according to my effort and what I do. And we do a lot. Now, here's the deal. We pay anybody who's got a valid license. I don't care if they're a buyer agent, a transaction broker, or a no brokerage relationship. Making a difference. That's why on this, let me explain how you fill this up. You'll see here, just follow along with me on your paper. Broker's office policy to cooperate with all brokers except when not in seller's best interest. Check this box. On line 106. And to offer compensation the amount of, put 3% there, of the purchase price, or draw a line through that one where that dollar amount is, on 107. And then, right in the middle, to buyer agents who represent the interest of the buyer, not the seller in the transaction. Check on the next page, 109, check that box. And to offer compensation in the amount of 3%, the dollars line, a line through the dollar amount. Broker who has no brokerage relationship with buyer or seller. And to offer compensation in the amount of 3%, draw a line through the dollar amount. The transaction brokers for the buyer. Do not check the one that says none of the above. If you're not willing to cooperate with anybody, the MLS will not let you accept it, will not accept your listing. MLS, when you get down to where the commissions are, you're gonna see this. You will see down where they show the commissions, you'll see COTB, COBA, and CONR. What does COBA stand for? Cooperating broker, cooperating office, excuse me, buyer's agent. Cooperating office, transaction broker. Cooperating office, no relationship. We will put the 3% beside of each one of those. Because we don't care what kind of representation you have with the buyer, as long as you have a valid license. The conditional termination. The key word there is not termination. The key word is conditional. Which means that, and here's another place where they had selected and marked out conditional and changed it to unconditional. Not in this lifetime. Unfortunately, the agent sent me all this after it was executed and put in the MLS. What kind of position did that put me in getting that changed? Yeah, my hands are tied. And we had one of those little, if you ever. It's ridiculous. What was backed up in this? But I wouldn't put them in the position to go back and, I probably should have. I probably should have told them that we didn't accept it, and this is all we'll accept and send it back, but I didn't want to do that to them. They had already mutilated themselves bad enough with what they accepted and what they're going to have to deal with if this thing doesn't sell reasonably quick. Because I guarantee you that person's going to be down their throat if they don't. Now, conditional termination. Number one, if a seller wants to terminate the listing agreement, the broker has to agree to it. They can't just walk away. That's what the first part of that says. If they agree to it, the seller must sign a withdrawal agreement, reimburse the broker for all direct expenses incurred in marketing the property. Which I have never seen that done, but it could be. And pay a cancellation fee, $500 is minimum. Broker may void the conditional termination, and seller will pay the fee stated in paragraph 6 less cancellation fee if seller transfers or contracts to transfer the property or any interest in the property during the time period from the conditional termination to termination date and protection period if applicable. So in other words, that listing still exists. Again, the only way to get around that would be to do what? List it with another broker. Now, here's the deal. You know you're supposed to be taking 1-year listings, right? Minimum. Anything less than that requires permission. We used to put in the additional terms that the penalty, that the listing can be terminated after 6 months with no penalty. I don't want you to use that. Well, that month they will have the cancellation. Used to be that was kind of standard, and then we kind of decided. And also, too, if I'm in a marketplace where the days on the market are pushing 6 months or more, I could be wasting my time here for 6 months. So that also plays into it, because that's one of the questions I'm going to ask you in deciding whether or not we can offer that as an alternative to a 6-month listing. I'd rather have a year listing with the penalty dropped up to 6 months than have a 6-month listing. Because in reality, you have the same thing, but minimally it's still a year listing. Everybody okay with that? All right. Dispute resolution. Very important. Line 129, never, ever, never initial notice. Never, ever, never. Why? You initial that, have the seller initial that. You have eliminated our ability to litigate. because by initialing that, we are agreeing to arbitrate rather than to litigate. Why? We want to hold the litigation over their head if they start playing games with us. They're not going to be as afraid of arbitration as they are litigation, because litigation is going to cost them what? Money. Arbitration isn't going to cost them much money. That doesn't mean that we wouldn't wind up arbitrating to resolve it. We just don't want to eliminate the ability to litigate prior to the arbitration. Under additional terms, in individual offices, some of this stuff will be pre-populated. For example, if your transaction fee is $295, it will say here the transaction fee is $295. Now I realize we put it on the other page too, but it's also here. If this would be the place where you would put the paragraph that after 6 months the listing can be terminated without penalty, if we use that. Also, you want to put here, if you are taking a rental listing, you'd want to put here that if the tenant buys the property during the listing period, or for X period of time thereafter, we'd be entitled to a 6% commission. Or if you were in Kings Point, it would be an 8% commission. And any other provisions that you want to put in there that would be applicable to that situation, that's where you would include them. And then the page I have the biggest issues is that page. Why is that? Because I have to constantly remind you to sign the listing agreement. The date, if you're going to do it, through the system, I prefer the seller put the date in there, but we can also do it. This is the part I'm most concerned with. I'm not worried about this. I know you'll get, well, I can't say that. I had one not too long ago. There was no seller signature. Agent signed it, but the seller never did. This section right here, I'm sorry, from 164 to 167. You need to date it. On the left side of where it says authorized listing associate or broker, on the right side you need to print your name and sign your name. Then you need to put whichever company it is, telephone number, and the address. And this, people, is critically important. It's more important than your signature. Because by law, we have 24 hours to return a copy of the listing agreement to the seller. Now, that's not 24 hours from when they sign it. That's 24 hours from when you sign it. It doesn't mean it has to be in their hand. It has to be on its way. And there's two things, when and how. Why? They walk in and want to audit that file. I better have a good explanation for why that's not filled in. Unless you've got some other proof in that file that you send a copy to them. Of course, when I send that, oh, by the way, when you send out an email or you receive an email on a particular file, you're going to forward, number one, if you're sending out an email, say to the seller about something or to one of the other agents about something, you send it to whoever you want to send it to and you BCC it to the file. That way you now have what? A running log of all the emails that have gone back and forth in that transaction. You have no clue how important that is. Because when we start debating over who said what and who did what, and you can whip out all those emails, I've ended a lot of conversations because the emails proved we were right and they were wrong. So I never should be copying and scanning and doing all that stuff. I can send every email, and I see by doing BCC, nobody knows what? That it's in the file. It's like when I send out the email about the training. All you see is my name and yours. You don't see the other 150 people that are on that list that's sent out, because I send it to every office.
But Dale, let's say you do Now, why you would do this, I don't know, you just do email and like that, but let's say you do mail it or fax it.
Mm-hmm.
You
No
would
problem.
have to scan a copy into the,
Yeah,
that file?
yeah.
Okay.
Or you know what, you go into your notes, in your app file,
Yeah.
and in your notes you say, returned a copy of the listing agreement to the seller by mail on December 23rd, 2012. That's all.
That's good to know.
Because in the app file, in the middle of it, when you first create it, there's a box, and when you first create it, it said notes. And you can go into that anytime you want and add notes to it. You could put 18 pages of notes. And it's great for me, too. For example, one of the things I like seeing there is, once you have a contract on it, I like to see who the listing agent is and the selling agent. If the listing agent is you and Caldwell Banker was the selling agent, all you have to put, listing agent, Gladys, selling agent, MLS. Because it doesn't matter who the office is. Because on the sales form, you'll put who the selling office is. So you don't have to take up a lot of space. I already, when you tell me MLS, what you're telling me is what? It's not one of our companies. Now, if let's say one of the Kings Point agents lists it, but then you bring the buyer, you can put, selling agent you, listing agent, then you need to put their name, the full name, not, Kathy or Sue or whoever. Because I obviously recognize that they're with KP, or you might just want to put with KP. All right, that takes care of the listing contract. If you're talking to a sibling whose parents have died, and they were in the unit 2 times the whole time they lived there, how could this person legitimately go through this and answer this? I mean, their answers for the most part would be bogus. Because it'd be no, 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 no. What I would do with that is this. Somewhere on this first page, I would put the owner never occupied the unit. And has answered the questions they know the answers to. Or just the fact that they've never, which now tells me why the thing might be blank. What a lot of agents will do is draw a diagonal line through each page and have the seller, that person, the seller who's now the seller, put cited at the end. And that statement at the front that the seller never occupied.
And that works for you?
Yeah. Because in reality, I don't have a problem with that for one simple reason. Their answers, if they would answer no. Now, here's let me show you why I'm making the statement. When they answer no in one of those questions, what does no mean?
No. It doesn't mean I don't know, it just means no.
To the best of their knowledge. It doesn't exist. So when they answer no, no doesn't mean it doesn't exist. No means to the best of their knowledge it doesn't exist. And the reason I point that out is I've had a lot of agents say that they've had sellers that have been reluctant to answer no. And the response is, well, I'm not aware of it, but I wouldn't want to swear to it. In other words, talking about honest people here. So you need to explain to them before you even start what no means. They don't have a problem with yes. If they can answer yes to something, they've got something to put down about what that yes is about. It's when they're answering no. They don't want to be called on the carpet when it's found out it did exist. Because they don't want to look like they're lying. But if I explain to them no, by marking no, all you're saying is, I'm not aware. You're not saying that situation doesn't exist. Now, again, you want to read through this. But of course, also, what I just said is basically reiterated in this part right here. This is not a warranty or a guarantee. It's simply the seller making an honest attempt to disclose whatever they know that can materially affect the value of the property. Now you understand why I tied this back to that statement in the contract that talked about material facts. Because why am I using this? To help the seller identify what a material fact may be. Because what if a seller said to you in the contract, well, give me an example of what you mean by material fact. In other words, I don't really understand what this means. Well, this tells them, in a condominium situation, these would be the things that would be material facts. As a justification for why you use that. Because a lot of companies don't use it. Why? Because they're not required. So you learned that the seller was required to disclose anything that was a material fact, that affected the value of property that was not readily observable. But it didn't require the seller to put it in writing. So legally speaking, the seller has no obligation to fill out this form. I'm doing it for CYA. For, not just for me, but more so for the what? Seller, because it shows that the seller made a diligent effort to identify things that he would have or she would have an obligation to disclose.
Let's go to the second page of this.
To number 5, it says environment. Then I want you to do this. Keep that page out where you can see it. But go to the end of that document, which is, I think, 3 more pages. Don't turn it over. Now, go past the last page. Got the last page. That's the next page. Go to the next page after it. And you find the document that says Seller's Mold Addendum to Disclosure. I want you to look at that page, and I'll leave 5 up here where you can see it. Now that's 5 on the condominium disclosure. Tell me how closely it matches that mold addendum. So you'll notice that basically it's the same disclosure. A lot of people like to do the mold separately, but you look at that mold addendum, it's not just mold that they're talking about there. The Chinese drywall is also in there. So, I don't care whether you use the mold addendum or not. If you like using it because you like to keep the mold separate, I don't have a problem with that. That's fine. But notice there's some repetition there. It's not exactly the same, but it's pretty close. Now,
Are there benefits to using it?
I guess it draws attention to that rather than being buried in another 5-page document. But like I said, if you point out the things as you go through it with the seller, it's like you're repeating yourself for the most part. If you got sellers really paying attention, they're going to say, wait a minute, didn't we just do this? So, I don't care whichever way you do it. It doesn't, it's not a big difference to me. Now, here's something that's very important. If you're going to use this form in your listing, make sure that when a buyer shows up, you send it to the selling agent so the buyer can review and then sign and send you a copy back. Because if you don't do that, it's a waste of time. Oh, by the way, another agent from another company asks you how much you charge the seller, none of the business. Have no obligation whatsoever to tell them. All they have the right to know is what? How much we're willing to pay them if they present as a buyer. Seller, that if they accept an agent as a single agent, they are now liable for the acts of that agent. Mr. and Mrs. Seller, do you really want to be liable for everything your agent does? So if you're trying to compete with a single agent, and you're looking for something to give yourself an edge, there it is right there.
Can you repeat that, please?
Yes. As a seller or a buyer, if I work with an agent as a single agent, I am responsible for this agent's actions. Whereas if I'm working with a transaction broker, I am not responsible for their actions. So, and then again, that's something I wouldn't really get into if I was a single agent. But if I'm fighting with a seller because they're saying, I would list with you if you're a single agent, but I know I can't do that, I've got to have some tool to overcome it. I'll tell you what, if that's the reason they're not listing with me, they're not paying attention. Because there's 10,000 other reasons why they should be listing with me. I don't want to harp on that. So I can use that little statement as a zinger to get out and get away from it. I want to go back to what's really important. The representation is as important as results are. And what you want, Mr. and Mrs. Seller, is what? Results. Results means what? Best price and terms in the shortest period of time with the least amount of hassle. So to me, when I don't need to deal with a topic because the topic's not applicable to me, I take back, I acknowledge it, and I move on to things that are more important. Now, my question is this. Would this document be appropriate when I'm putting together a sales contract? Or is this document specifically used when you're taking a listing?
Listing only.
Listing only. There is another addendum that you use for the sales contract. Would I use this form if I was taking a rental listing? Why? Because it says seller/landlord. Now, what is my obligation regarding this lead-based paint? Is disclose what their obligations are. That's my job. Which is what this document does. And it discusses both a contract for sale and the lease requirements. Now, you got all this, but it's kind of simple. If the seller has any knowledge of the fact that there is lead-based paint in the home, they have an obligation to disclose it. If they have any inspection reports or other documentation that would show that it did or didn't exist, they would have an obligation to disclose. The buyer has a 10-day right to do a risk assessment for lead-based paint. They can choose to waive it, but they still have an obligation. They have the right to do that inspection. And that's what this form, in a nutshell, is telling them. Now, is this applicable to all properties? Yes or no? No. What properties is it appropriate for?
Residential.
Residential. What other limitation is here? Year built. If it was built in 1978, would you have to use this?
Nope.
Would I have to use this form if it was built in 1978?
No.
Yes, because it says prior to 1978. So that means it had to have been built in 77 or new or older. If it was built in 1978, I wouldn't have this disclosure requirement. Yes?
But it's not just talking about lead-based paint.
No, I'm not talking about this.
Oh, I'm sorry.
That's not where I am right now.
Sorry.
Let me get to where I am.
Sorry about that.
That's okay.
Okay, thank you. That makes sense now.
Hold on, that just confused me. So if it says year built, 78,
Disclosure is not required
disclosure.
because
Lead-based paint was before.
it says right here, built in 77 or earlier. Oh, but I'm sorry, that means you'd have to be able to read. Apologize for that. Should be asking you things you're not capable of. You may have been able to read before you got the license. Unfortunately, reading ability seems to decline once you have a license. I just love it when an experienced agent tells me, I'd like to know that was the contract. That tells me how many times they've actually sit down and read through it, you know, what it really says. If you sit down and read through it, there's very little in the contract that's that hard to understand. It's just a question of ignorance. It's not a question of the inability to understand what you're reading. I mean, yeah, there's little things here and there, and the clarifications. Now, so what we really need to look at, unless you can't read, is the second page, because this is where we have to do something. About halfway down the second page, you get this information sheet was provided by, and that would be your name, by the licensee to seller or landlord or whatever date, month, and year you did it. Then you've got two things here that the seller has to answer. The first one is, do they have any knowledge of lead-based paint or lead-based paint hazard? And the second one is, do they have any records or reports regarding lead-based paint? Whether the reports are positive or negative is irrelevant. Because maybe somebody did one, a previous buyer, and they found lead-based paint or they didn't buy it. Or maybe the seller did it themselves when they bought the property. Under what circumstances would you check both A and B in these two? Under what circumstances would you check both A and B? Maybe you forgot how this works. I ask the questions and you're supposed to answer. Under what circumstances would you answer both A and B in those two questions? None.
Right, that's why Rose Singer should.
Because I couldn't have knowledge and not have knowledge at the same time. Although I've had agents check both boxes. Again, that I can't read disease. Because you're sitting there thinking, well, I can't think of anything.
Right,
It wouldn't make sense to have them both checked.
right.
But I know he's trying to trick me.
Yep.
I don't have to trick you, you trick yourself. All I have to do is just ask the question. You're looking for some deep-hitting meaning. It doesn't exist. And then notice at the bottom there's a place for them to sign a date. Again, no place for the buyer, because this is telling the seller, here's your responsibility regarding lead-based paint when a tenant or a buyer shows up. So they're restating what the law says, explaining in each one of those sections what it means if you have a contract, what it means if you have a lease. And what's the big deal about lead-based paint? What's the problem? It'll make you dead. It won't make you sick. It basically, it does not like your nervous system. It kind of puts your nervous system on hold. And kitties like eating it because it's like eating potato chips. Because with the lead in the paint, when the paint peels, it peels off in chunks. This is a modification to listing agreement. This is the form that you need to use if you make any changes to the listing contract, whether it's price, or terms, or bonuses, or extensions. Or if you're going to terminate it, this form would be used. So if you never make any change to it, and it's never terminated, then you would rather be using the form. And notice that here under this termination section, you've got conditional and unconditional. I think it would be rare that we would agree to unconditional. Although there's some sellers we had that would probably be the smart thing to do, to vest yourself totally. But again, that's not your call. That's the nice part of it. All this mad stuff is not your call. I'm just a messenger, don't shoot me. But just be conscious of the fact that if you do need to make changes in the listing agreement, this is the form for it. Even if you're going to, raise the price or lower the price in the MLS, You first have to have permission to do it. So you have to be able to document that the seller has agreed to that. The next document is the seller's real property disclosure statement, which should look on the surface exactly like the condo disclosure statement. And for the most part, it's pretty much the same, even if you turn to page 2 and look at number 5. Where you'll find the differences is there's a section that talks about the homeowners association versus on the other one where it talked about the condo association. But a majority of it is the same. And I have the same comments about the first page. Please make sure that information is completed. Comment back on this. In the MLS, there's this, when you look and you're looking at a property in the MLS and you're looking at the detail, in the left-hand column, there's a place there that says attachments. You could literally take this document and attach it to your listing in MLS. And then you could put a note in the broker's remarks. Please see condo disclosure statement in attachments. So that you've done what? You've already set it up where the selling agent can pull this down for their buyer to see it. Now, when would I send this disclosure statement to the selling office? I'd want to send it to them before or after the contract was signed. Before. And they should be asking for it before. So when you call up the listing office to tell them you're going to be making an offer, I would ask them to email to me the disclosure statement. Or if they're calling me, say, hey, we're getting ready to make an offer, please see the attachments in MLS. I put the condo disclosure, the real property disclosure statement in there for your buyer to review or your tenant to review. And remember, this would be the same as if you're dealing with a tenant. Now it serves its purpose. It's not just, 10 minutes of wasted time filling it up. The next one is the short sale addendum to exclusive buy the sale listing agreement. Question: would I use this document when I have a sales contract?
No.
Would I use this document when I have the sales contract? Yes or no?
Well, it's a short sale?
Yes or no? Assuming that it's a short sale, yes or no?
Yes.
No, because it says addendum to exclusive buy to sell listing agreement. It doesn't say addendum to sales contract. There's a different addendum that you use when it's contract time.
Oh, listing agreement.
This is a listing agreement.
No.
I know. Well, I apologize.
It's the reading
I'm asking you to
again.
do something you're not capable of.
I know.
See, I hate to be right all the time. It's just terrible.
This would be so wonderful.
It's such a burden. But it's funny. It's true. It's there. You
Really?
see it.
Yep.
It just doesn't sometimes
I only
register.
saw a short sale, figured out how to go with the short sale, not continuing with that, but it's
Yeah.
a-
Reading the rest of the sentence
Yeah.
is real important.
Yeah.
But see, people, you know that the average agent doesn't. So if you take the time to sit down and, like I said, read through these documents as if you had to take a test when you were through, you'll be surprised the difference that it makes when you're out there in real life and you're actually using these things. Because you're going to be comfortable with what it says. And as you go through and review it, things that you're not quite sure of, you send me an email or you pick up the phone and give me a call and say, Dale, I've been reviewing the listing contracts and on page 3, paragraph 4, I'm not really totally comfortable with what this is saying. Can you go over it again? See, my objective is you to be comfortable to sit down in front of anybody, a buyer, a seller, or another agent, and go through this contract and feel comfortable that you can give a brief explanation for anything they have a question on. And most of the time, you can give them the explanation by simply showing them where it says it in the contract. Why? Because if it says it in the contract and they've agreed to it, it really isn't open for discussion anymore, is it? If you want to discuss it, knock yourself out, but you're wasting your time. Maybe you should become more familiar with the contracts that you're using before you start complaining. Of course, I wouldn't say any of that to them. Now, let's take a look at this short sale. Now, first of all, if I'm gonna take a listing on a short sale, I wanna try to get them hooked up with the attorney who handles short sale for us. Because we'd like the seller to work through that. Now, the ones that are pre-approved for short sale, at least on their side, that in other words, they checked out the seller and the seller's assets, or the owners, he's not a seller, he's the owner, the seller. And there is evidence there that he does not have the ability to pay. So you have to realize somebody that says, okay, I'm gonna do a short sale so I can get around the fact that I'm paying on something that's worth a whole lot less than I'm paying on. If you're making your payments, you're not gonna be approved for a short sale. So basically, you have to run your credit into the ground in order to qualify for a short sale. Because as long as you have the financial ability to make the payments, they want the payments. They don't really care the fact that you're paying on a property that's now worth half of what the mortgage balance is. Again, that's where the attorney can help us to position. They know how to position it, and they have the clout to be able to do it a whole lot more than we do. Not that we can't handle it, because I know agents out there that do short sales all the time. And they negotiate with the bank, and they do everything. They've also been doing it for 5 or 6, 7, 8, 9 years.
Was watching Farrah.
Yeah, Farrah's good at it.
Holy.
Well, she's only good at it for one reason.
That's what she
Because
did.
she took the time to learn how to negotiate with banks. But one of the first things you want to do when you take a listing to short sale is you want to get the seller to get a document from the lender that says you can talk to the lender on behalf of the seller.
Okay.
And every lender has a form, and they can just email the form to the seller. The seller can fill it out and send it back to them. In number 4, it says, seller acknowledges that the commission offered to the cooperating broker under the listing agreement may be modified if the lender reduces the compensation to be paid by the broker. How much? Because you'll find that if you, for example, the commission was 6%, it's going to be 5%. Transaction fees, they're not going to pay. So unless you can get it out of the buyer. That's why in your listing agreement, in the MLS, there's wording that has to be there. This, and write it down. You can put it on this document anywhere you want to put it. You have to put this under broker remarks in the MLS. This is a short sale. The third-party lender may reduce the commission. The commission will be split 50-50. Because, let's say it's 3% that you gave them and you have a 6% listing, and bank says 5%, we'd get stuck with 2 as the listing agent, and they get their 3, because in MLS we put what? 3 without that explanation.
This is why I put 7 when there's short sales. So is it going to cut them to 6?
Yeah, they may cut them to 5 even if you put it at 7. But yeah, hopefully they'll only go down a notch. Sellers are going to be really excited to venture into this after reading this disclosure. Again, that's why if I can get them to agree to speak with the attorneys that do the short sale negotiation for us, I want them to speak to the attorney before I go on the listing appointment. Because if they're comfortable and they're going to go that route, then we got a whole different situation when you're dealing with it. Because guess what? All this has probably already been explained to them by the attorneys. Because obviously that's a consultation explaining, this is how this is going to work, here's what we do for you. Well, for example, let's say that you're upside down $50,000. You've got a 401k that's $100,000. Guess what? They want you to do what? If you're $50,000 short, they want you to show up with that $50,000.
And that's why people would.
That's the reason you may choose to walk away.
That makes sense.
But then that means what? I face the deficiency judgment. Also, another little thought to think about. I've got mortgage relief. Let's say it's $50,000, and let's assume that they relieve me of liability for it. No deficiency judgment. That means I've just made $50,000 as far as the IRS is concerned. Now, fortunately, if it's my primary residency, I can use the fact that up to $250,000 if I file singly, or $500,000 if I file jointly, profit can be eliminated. If it's an investment property or it's not my primary residency, then I'm facing the taxation on that one. Why? Because in the IRS's opinion, the bank just gave you $50,000.
Which is probably why you should have a lawyer check all this stuff out.
Yeah.
before you ever-
Yep. And besides the fact, it's a lot of work on our part if we do all the negotiations and stuff ourselves. The only advantage there is if you do all the negotiations yourself, you can negotiate with the bank and get paid extra for doing the negotiations. Hmm? Yeah. Of course, all that money has to be paid to the company. You get your fair share. Okay, I think maybe we hit the end of the line.